Now let's go to fixed term employment. Now I make it sure that I discuss it separately from the discussion of Article 295, wherein I discuss the regular employment and the exceptions therein. Because I honestly believe that this fixed term employment has no place in Article 295. However, it is decided by the Supreme Court, and we have to go back to Article 8 of the Civil Code, wherein the decisions of the Supreme Court will become law of the land, because their interpretation of what the law is. So let's go to fixed term employment. This is according to Supreme Court, the last exception to regular employment, wherein in this case, the employer and the employee can stipulate the term of their employment, especially the period, under the principle of freedom of contract under the Civil Code. This is in the case of Brent School Incorporated et al. Versus Zamora et al. February 5, 1990. So when can you consider fixed term employment as valid? There are two requisites. The fixed period of employment must be knowingly and voluntarily agreed with the parties, without any force, duress, or improper pressure being brought to bear upon the employer, and absent any other circumstances vitiating his or her consent. Second, it satisfactorily appears that the employer and the employee dealt with each other more or less equal terms, with no moral dominance exercised by the former over the other. You have the case of Caparuso and Kindipan vs. Court of Appeals et al. February 5, 2007. So regarding the requisites, you must memorize. You have to give these two. When it is voluntary agreed with the parties, and the parties dealt with each other in equal terms, without dominance of one over the other. Although in reality this does not exist, because there will be no equal footing between the employer and the employee, and the employee will be compelled to accept the fixed term employment because the employee is in need of wage or salary. But anyway, that is the ruling of the Supreme Court. However, the Supreme Court put a warning. In order to avoid abuse, the Supreme Court said that this fixed term employment cannot be used ordinarily by the employer. Otherwise, the security of tenure will be violated. So therefore, the employer and the employee can agree on a period of 2 years wherein the employee will be hired and the employee will not become a regular employee, even if he or she is performing an activity that is necessary or desirable in the usual business or trade of the employer. In other words, it should not be used to circumvent security of tenure. In fact, the Supreme Court has used the word stern admonition, when according to Supreme Court, it is apparent that the period was imposed to preclude the acquisition of tenurial security by the employee, then it should be struck down by being contrary to law, moral, good customs, and public order. Of course, in that case, the Brent School decision was cited, but I'm referring to the case of Cherry Price et al. Versus Data Philippines. September 30, 2008. The Supreme Court even enumerated examples where there will be valid fixed term employment. You have the case of OFW. You have the case of officers of the school, the dean, college secretary, principal, administrative officers. Then you also have the president of the corporation, vice president. You also have the replacement of a teacher who went on leave. In the case of Mercado et al. Was the AMA Computer College. So in my book, I put there the legal arguments for my objection to fixed-term employment. But for purposes of bar examination, you have to stick to the ruling of the Supreme Court. The objection to the validity of fixed-term employment is only for academic purposes. So you better get a copy of my book and you read. I extensively put there the arguments and the cases just to prove that fixed-term employment is not contained or not allowed under Article 295. Remember, the bar examination do not go against the tide. Since the Supreme Court allows fixed-term employment, then just memorize the safeguards, assuming that the requisites are there, then rule that there is valid fixed-term employment. If you will be asked what are the requisites, then of course you know you cite the Brent School ruling. The next topic would be probationary employment. This is a period under Article 295. In fact, it is not a type of employment. It is provided in Article 296. This is a clear example of exercise of management prerogative wherein the employer is given choice under the law to hire and select employees. However, there is a limit only. The employer is given a period of 6 months to evaluate the employee and for the employee to pass the standard. So in other words, I would like to reiterate, Article 296 is one of the few provisions of the Labor Code where the management prerogative to hire and select employees is recognized. Under Section 6, Book 6, Rule 1, the implementing rules of the Labor Code, it is defined there. Probationary employment is where the employee, upon his engagement, is made to undergo a trial period during which the employer determines his fitness to qualify for regular employment based on reasonable standards made known to him at the time of the engagement. First, you're allowed to hire probationary employees before they become or qualify regular employees. First, you have to appraise the employee of the standard. The standards must be reasonable. The standards could either be qualitative or quantitative. And the employee must be appraised of the nature of the standard. Another thing about standard, the employee must also be informed on how to pass, what is the passing percentage in order to qualify and become a regular employee. And in the contract, it must also be stated how the employee will be evaluated and when the employee will be evaluated. So therefore, again, there is necessity for probationary employment contract to be in writing because there will be standards that will be contained, that will be provided for the employee to comply in order to become regular employees. Otherwise, the treacherous human memory would prevail. We will forget everything that we entered upon engagement of the employee because we did not put the contract into writing. In this case, the employee is performing an activity that is necessary or desirable in the usual business or trade of the employer. However, the employee is not yet considered a regular employee because the employee is made to pass through a trial period. Once the employee will qualify, based on evaluation, the employee will become a regular employee. So what will happen if you don't appraise the employee and there is no reasonable standards contained in the contract, or in other words, the standards are vague, then the employee is deemed regular. Also, when the employee is made to perform or is allowed to work beyond 6-month period, then the employee is deemed regular. Regarding the computation of the 6-month period, if you will be asked, remember Article 13 of the Civil Code. The first day shall be excluded, the last day shall be included. If there is a conflict between probationary employment and fixed-term employment, according to the Supreme Court, in the case of Universidad de Santa Isabel versus Simbahon Jr., April 2, 2014, the probationary employment contract will prevail because it is provided by law, while fixed-term employment is provided by the Civil Code. So if there is a conflict between law over contract, the law will prevail. This is in line with our argument that fixed-term employment should not be allowed because it is not provided for by law. And where the Supreme Court is confronted with a situation where a provision of the labor code go against a civil contract, then the labor code will prevail. Regarding the due process, let us look at the aspect of due process in probationary employment. The first component of due process is what I mentioned, when you appraise the employee of the standard and how to pass the standard and how the employee will be evaluated. Those are the standards of due process. The second due process is that the employee must be given notice as to the result of the evaluation. If he failed or she failed to qualify, then the employee will begin a notice of termination based on the disqualification or the failure to comply with the requirement or to pass the standards. In the absence of the first due process, the employee becomes regular. Now, if you don't also send notice to the employee that the employee failed to qualify, then the employee becomes regular after a 6-month period. In other words, the only way you can terminate a probationary employee would be based on just cause or authorized causes and failure to qualify the standard laid down in probationary employment contract. You have the case of Robinson's Galleria versus Irene Ranches, January 19, 2011. What are the exceptions to the 6-month period in probationary employment? First, you have Article 295. It will tell you that if it is covered by apprenticeship agreement stipulating a longer period, it is an exception. Another exception is when it is established by company policy or when the same is required by the nature of the work. Just like in the case of Iluminada Buiser et al. Versus the Honorable Vicente Lugardo. It's an old case, January, it's July 31, 1984. Then you also have a probationary employment period not more than 3 years in the case of school teaching personnel, and not more than 6 months for non-teaching personnel. You have that in the manual, 2010 revised manual of regulations for private schools and basic education. Then last exception would be the extension after the employee failed to pass. Then the employer extended ex gratia, meaning act of liberality on the part of the employer, giving the employee a second chance. If the employer will give the employee a second chance, it is highly recommended that the employee should make the request for second chance in writing, and the employer will give the written reply before they enter another provisional employment contract. Otherwise, if they will go for the second provisional employment contract and then the employee is terminated after the second provisional employment contract, the employee may go to the labor court, file a case for illegal dismissal alleging that he has become a regular employee. So that is dangerous on the part of the employer. It is substantial evidence that is required, so the employer must prove that the employee requested for an extension and the same was granted. Okay, so the purpose of hiring probationary employee is only for the employer to determine the fitness of an employee for a regular position, not for other position. It is my opinion that you cannot have a project employment, you cannot have probationary period in project employment. You cannot have probationary period in seasonal employment, and you cannot have probationary employment in casual employment. So this probationary employment period applies only to position for leading to regular employment. So that's why the law is very strict. It provides a limitation as to the number of months. Always remember, probationary employment is not a type of employment. It is only a trial period, which is a valid recognition by law on the exercise of management prerogative to hire and select employees.